There's a Pennsylvania case that I think that was already done.
Was it okay?
Yeah, that's done. And I don't think that went to the Supreme Court, but that created problems in Pennsylvania, but it was very narrow. It was simply address Pennsylvania. What the plaintiffs in this case are challenging, and the Maryland case are challenging, is they want the court to adopt a new rule nationwide. The issue is, the way the Constitution was set up is that the states determine the legislative maps, and you do it by whatever party's in power in the legislature draws the maps, but it's a bill. It's got to pass both houses in the identical form. It's got to get signed by the governor, and then it becomes the law. Now, you can imagine that if the three bodies aren't all the same party, that sometimes they don't agree. And that happened. In 2002, the maps, well, we had the 2000 census. The governor and the legislature were two different parties. They didn't agree. And so ultimately, a federal court drew the maps for Wisconsin in 2002. No one ever alleged that those maps were unfair or biased or politically rigged. And yet, in 2010, when Governor Walker won, when we took back both houses of the legislature, the maps that happened on were the 2002 maps that the court drew, that no one ever claimed were unlawful in any way. But then, of course, when we had the 2010 census, the Republicans were now in charge, and they got to draw the maps. And the other side howled. This has been a challenge forever. And you know, they call it gerrymandering. I don't know if you know the root of that term, but it's a combination of two things. It's a combination of the name of a former Massachusetts governor, Elbridge Gerry, G-E-R-R-Y, and salamander. Made a contraction of those two words. And what happened was, in Massachusetts, they drew maps. They drew a map that actually had a district that looked an awful lot like a salamander. It had a long, skinny tail, dropped down a little foot that came down, got a little wider, and then there was the head that dipped up here. It was a bizarre-looking map. And Governor Gerry signed that, and they thus created the term. But to put in perspective how long this goes back in our history, Elbridge Gerry participated in our Constitutional Convention. This is nothing that would surprise the Founding Fathers. That I think they'd be surprised that we ended up in a two-party system the way we did, but they wouldn't be surprised that, yes, politics does drive how maps are drawn. You know, as we're doing this, if you have questions, want to talk about specific topics, I'd love to do that. Because otherwise, I'm going to keep going on different things. Go ahead.
Thank you for asking. My understanding of the Legislative Review Bureau is that they do most of the language for bills. They do the analysis, they do the legalese, and they do the writing of the bill. So I found your statement about the courts taking everything that's signed by Governor Walker to court when I thought that we had that legal presence involved before it even got to the point of signing it into law. So could you explain a little bit what the LRB does relative to?
Well, they certainly do assist. The Legislative Reference Bureau assists the legislature in crafting the statutes. A legislator, you know, most of them aren't lawyers. Good, right? Most of them aren't. It's okay to have a few lawyers in there, but a lot of farmers, a lot of businessmen, crafting legislation, not necessarily their forte. And so that the Bureau exists, the LRB exists to help them craft the language, to help make sure you don't miss things. Like you change one section of the statute, you got to make sure that there's another one over that has a cross-reference. You've got to change that too. So they help make sure you find all of those things. But ultimately, once it's passed, you know, anybody with $75 can go to the law. I don't know what it costs to file a lawsuit these days. It used to be $75. Go file your lawsuit and challenge it, and it's going to put us through the paces of defending the law. We are still defending Act 10. It was a duly passed and signed and enacted law. It's been all the way up to the Supreme Court and survived, and yet we have more challenges. Right to work we're not done defending that, although we have succeeded. There were 3 cases filed against right to work. 2 of them are concluded. Those are the 2 that were the meatiest. The one right to work case that is left deals with a very small issue, just really whether employees would be required every year to renew their union choice. And of course, unions don't want that. They want, once you're in, nobody ever asks you again. That's the one that's still up, and we may lose it, but if we did lose that one, it wouldn't cause the rest of right to work to fall, because it's such a narrow piece of it. We have, but I don't have a better answer to that. That's just simply what's happened. Going all the way back to the early 1800s, that has become the role of courts to oversee the constitutionality of statutes. They've gone way beyond what was ever intended. And unfortunately, we end up with an awful lot of activist judges who conclude that their job is to decide what's a better policy. It's absolutely not. Frankly, it's not my job either. As Attorney General, I defend the law the way it's written. As a matter of fact, I've defended laws that I don't like. And the media always asks, when I tell them that, they always say, well, which ones? And I say, well, I'm glad you don't know, because that means I did my job well. If you can't tell which ones I don't like, there's one I'll share with you, because this one, the legislature has since changed, so I feel like I'm off the hook. But you know, my job when I defend the laws passed by our legislature, when I do that, they're my client. And no attorney would ever go make public statements critical of their client, so I don't do that. So I would never reveal that, you know, my heart's not really in this defense. No, I'm gonna fight and defend it. But there was one law that provided cover for community up in one of the townships up in St. Croix County. And their local ordinance provided that if you've got, as a family, you've got 2 lots that you own together, adjacent to each other on a lake property, you can't subdivide those and make them into 2 cabins or sell one of them off. Well, there was this family up there that had this property for decades when the law was different. They bought 2 lots. They were distinct purchases, distinct parcels on the tax code and everything. They had built a cabin on one. The other one they always left open as kind of a playland, you know, to do things on. Well, when Mom and Dad passed the place on to the kids, I think ultimately they just couldn't afford it, because on St. Croix Lake, I think the property taxes are kind of high. So they were going to sell off the other lot to help cover the costs of the other place, the lot with the cabin on it. Well, in between the time when they bought those 2 lots and now, the town changed the zoning to say you can't split those anymore. That's a terrible law, and unfortunately, state statute covered them on that. We fought all the way to the U.S. Supreme Court on that one, the Murr decision, and we won. That was my job, was to defend state law. Ultimately, the U.S. Supreme Court made the right decision to not interfere with the legislative actions of the state government, but that was a terrible law. And fortunately, our legislature, promptly right after that court decision, came in, changed it, and we're fixed now. We have better respect for private property rights than before that. So that's how I view my job, and I should. That my job isn't to decide which policy is best. My job is to defend the policy decisions made by the legislature. Because if I became a super legislator, you guys have a lot less control than you do. You know, you got Gundrum passing your laws on your behalf, or voting on your behalf for laws. You don't like it, you have enough local control, you can show them the road. It's going to be a lot harder to do that when you've got an attorney general who just undoes what the legislature just did, and it's the same issue with courts. Unfortunately, Court elections are in April. It's a time when not a lot of people get out and vote, especially when it falls during Easter week, and everybody's off on spring break, and they forgot to go vote ahead of time. We had terrible turnout in the WOW counties.